Hey guys, welcome back. Today we've got another wild courtroom showdown, and this one is straight out of Sovereign Citizen Theater. The defendant actually tries to argue that he's nothing more than a piece of paper. Yeah, you heard that right. But the judge? He's not buying a word of it. What follows is a clash between legal procedure and pure fantasy. The defendant refuses to accept reality, and the whole scene spirals into a battle of logic versus internet myths. Grab a seat, this one gets chaotic fast. Let's jump in.
Jesus Christ is King.
All right, cause number 2312933 and 2312934.
Appreciate it. Aren't you going to take a seat? No, I'd rather stand. So it's your hearing, sir. So okay if I stand? Is there something wrong?
Why do you have to stand so close to him?
The sign there that says no standing. Oh, well, okay. I was subject to those rules. I didn't agree to it. Anyway.
Okay, so there's a bench warrant.
I'm just going to take the seat. Thank you. Sit right here. If that makes us a little more comfortable. Is it uncomfortable if I stand up, Your Honor?
Well, depends on how you're going to act or behave today. Okay, so you failed to appear for court multiple times in this case.
Your Honor, just for the record, the named defendant is actual property, a registered trade name. And the case has also been certified as a fraud. I have court-certified documents to prove that. That should be on the record, and that's the reason why it was certified to be a fraud, because the plaintiff is a foreign-owned private corporation, which I have no contract with, and neither does the registered trade name. And the registered trade name has been used without authorization and permission, and is an act of identity theft. And that's probably one of the reasons also why the state has acquiesced that both cases are a fraud.
Defendant stuck in a fantasy world, convinced that a legal name is just a piece of paper and that somehow shields him from responsibility. But the court wastes no time proving that logic has no place in reality, as the judge steps in firmly yet calmly, laying the ground rules and making it clear that the law deals with people, not paperwork. The defendant clings to his theory, repeating it as if that will make it true, but the silence of the courtroom makes it obvious that no one is buying it, and from the very start we see the judge balancing patience with authority to keep the chaos under control. The analysis shows this defendant isn't here to argue facts but to play games with identity and contracts, while the judge refuses to be baited into nonsense and keeps the case moving, highlighting the clash between structured law and fabricated fiction where law always comes out stronger. And the real entertainment comes from the irony of a grown man seriously arguing that jail should accept paper defendants, setting the stage for a courtroom encounter that is both absurd and unforgettable.
Let me add one more piece of information. I am a foreign sovereign with respect to the privately owned foreign corporation known as the state of Washington.
Okay, so on the 9304, I am going to quash that one. He was in RALJ appeal status, and so I'm going to quash that one. But I do want to hear from the state on the 303 matter.
Oh, yes, on the 303 matter, Mr. Haywood was sentenced to serve 4 days in jail. He failed to report to the jail on June 29, 2023, and we're asking him to be taken into custody to serve that time.
No objection, Your Honor. I actually contacted the jail to make special arrangements to deliver the defendant with the special arrangements to not damage the paper, and the jail refused. So I attempted to deliver the defendant, and objection, the state has no standing as they are representing a privately owned foreign corporation, and the prosecutor is not licensed to practice law in this country.
Okay, so I think it's the 303 that he was convicted and ordered to do jail, and you believe that he didn't comply with jail because there's a docket entry that said defendant complied with jail. Maybe that was an error.
That was probably my attempt to deliver the defendant to the jail, but they refused.
At this point, the entire exchange drifts into pure imagination as the defendant acts like he can create his own legal universe by declaring himself sovereign, while the judge listens politely but makes it clear that reality is in charge, not fantasy. The clash is sharp, with the defendant stuck on endless jurisdiction arguments and the court focused only on enforcing existing orders, highlighting the contrast between the seriousness of a criminal case and the childlike logic of internet myths. The judge walks a fine line, keeping order without letting the hearing collapse into absurdity, while the comedy comes from the defendant's straight-faced delivery of nonsense, as if he's exposing a conspiracy, when in fact he's only exposing his own misunderstanding, building castles in the sky that the judge calmly pulls back down to earth, making the scene both frustrating and darkly hilarious.
Edible.
I understand, and I read look that he had not, as was the state's actually, he had not served the jail time.
And just to clarify, the defendant only exists on paper, just as the plaintiff only exists on paper. The jail refused the paper, and here we are today. And the state still hasn't proven standing yet, by the way, as well.
So, Mr. Haywood, it doesn't look like you did the sentence on the 303 matter. And so I am going to quash the warrant. However, I am going to have you serve that time.
Okay, well, I'll deliver the paperwork to the jail. That's fine. I tried to once before, but they refused it. And just to clarify, I'm not the defendant. There is nothing on there, nor is there any testimony from anybody as first-hand witnesses under penalty of perjury that I am the defendant. And I've uploaded plenty of documentation to prove I'm not the actual defendant. That is a registered trade name, matter of public record, and registered with the state. So if you want me to serve some jail time, then we're going to need to change who the defendant is, because I'm not the defendant.
All right, so can you upload a new commitment?
Yes, Your Honor.
And the reason they couldn't put my name on there as a defendant is because I'm a foreign sovereign with respect to the corporate entity known as the state of Washington, of which I have no contract with.
Okay, so with respect to the 304 matter, which is still pending, what's your position on the warrant, Ms. Fredenberg?
The state was going to ask for that warrant to be served.
Objection to jurisdiction. The state has never proven any jurisdiction and has no jurisdiction or standing. So any requests or statements from any representative from the state are a nullity and a fraud. And the jurisdiction is challenged. It must be established on the record. And it hasn't been, and it still isn't. You can do it now if you like, if you can.
Okay, so Mr. Haywood, you failed to appear many times in both of these matters, had many warrants quashed, and to be perfectly honest, I'm not confident that you're going to come back to court given the history here of failing to appear.
I will agree to come back to court on behalf of.
This is the turning point where talk ends and action begins. The defendant keeps insisting no authority exists, but the sheriff calmly steps in with handcuffs and proves otherwise. No matter how loudly jurisdiction is denied, the system still enforces its orders, and the judge, having seen this countless times, knows arguments won't change the outcome, so he signals enforcement to act, and while the defendant clings to words, those words collapse against the weight of an arrest order. The dynamic shifts instantly from debate to custody, showing that legal authority isn't about personal consent but about established law, and the irony delivers the entertainment. Watching someone declare themselves untouchable only to be escorted out of court is the perfect example of fantasy colliding with fact, and fact always wins.
The appearance fiasco was simply because the communication between the acting prosecutor at the time and myself. I have plenty of emails. So in one case, he said he was just going to reschedule with the judge. I told him, reschedule whenever you want. I'll go ahead and be there, and I'll bring the defendant with me. And next thing you know, there was a warrant for a failure to appear. So there's been plenty of fun and games with the acting prosecutor at the time. So it wasn't just a matter of not bringing the defendant to the court. The prosecutor was intentionally sabotaging the scheduling process.
Well, the prosecutor doesn't handle scheduling, the court does. So the court ordered you to be here, and then you weren't. So...
Objection, the court ordered the defendant to be here. I am simply bringing the defendant to the court to help try to solve the problem. The fact that the registered trade name remains as a named defendant is an act of identity theft and fraud, and that's probably why the state has acquiesced that the case is a fraud. I have the documentation here with me today in case if they decided not to upload it to the court record.
Well, you had your day in court on the 303 matter. You had a trial. You represented yourself or the defendant, whichever way you want to say it, but you represented the defendant yourself, and you were convicted, and you were ordered to serve 4 days in jail. You didn't do that. And so
The defendant was ordered to serve 4 days in jail, and I attempted to deliver the defendant to the jail, but the jail refused.
okay, well, I'm going to make sure that they don't, because I've done a new commitment for you today so that they won't refuse for the defendant to serve that time. I'm going to serve the warrant, and so we need a pretrial date, Madam Clerk.
There's no jurisdiction yet been proven or standing. Are we going to continue? That would be an act of fraud and treason.
Your Honor,
That's a felony. That's an arrestable offense.
I put both of them in one of our.
So we don't need anything on the 303. He's just going to serve a sentence.
Okay.
We just need the 304, and
Yes, I
I
have
see
the
that.
defendant here with me today. You can take him to the jail if you like.
Closing this case shows exactly why these courtroom encounters draw so much attention. The defendant poured all his energy into elaborate theories, but the ending was inevitable. The judge upheld the law, the sheriff enforced the order, and the defendant learned that fiction doesn't erase accountability. The analysis makes it clear that patient but firm judicial control keeps nonsense from derailing the process. And despite constant objections and challenges, the court stayed focused on the real issue: compliance with a lawful sentence. The breakdown reminds us justice isn't about clever excuses but about responsibility and order, and the entertainment value comes from the irony of someone rejecting authority only to be humbled by it in front of an audience. These endings satisfied because they reaffirm that reality can't be rewritten with word games and that the courtroom will always stay grounded in fact, not fantasy.
Court date is going to be September 13th. We probably need to change that since I'm taking him into custody. So do we have anything in August?
Excuse me, Your Honor. Are you testifying that I am the defendant under penalties of perjury?
I'm not testifying to anything.
Good. And here's the defendant right here.
All right.
Your Honor, we can do August 24th at 10:30.
All right, I can change that.
Thank you, Your Honor.
So August 24th at 10:30 in the morning will be your next court date.
I will be here with the defendant, no problem.
You're going to serve those 4 days, and then you'll be released, and nothing more will happen on that 303 case. You'll be done. And then this case will be heard August 24th at 10:30 in the morning. If you change your mind about representing yourself, then you can ask for help if you want it. If you don't want help, we don't have to have it. So we'll see you in August. I'm going to have you take a seat right over there.
I won't be here for the defendant August 24th. Would you like me to deliver the defendant to the jail?
I would like you to sit over there
Is there any standing
with the
or
defendant.
jurisdiction chosen, proven here yet?
Please go take a seat.
Okay, so let the record reflect no jurisdiction has been proven, and neither has the identity of the defendant definitively been established.
Okay, please go take a seat. Sonia Sesko, customer 2310242. Mr. Haywood, sit down.
Am I obligated to follow these rules?
You are going to sit down right now.
Do you have any jurisdiction? I don't believe you have any jurisdiction that's been proven yet.
Please sit down.
Are you threatening me with violence?
I'm asking you to sit down.
You only have authority over the defendant. You have no authority.
What are you doing?
Mr. Haywood?
You're escaping?
I got things to do.
No, sir.
What?
You are in custody right now. If you leave the courtroom, it's a felony escape.
That's a felony to put me in custody because you have no authority or jurisdiction or standing. You got some proof of
Okay,
that?
well, we are all being recorded, so if you leave this courtroom, it'll be a felony escape charge. Your choice.
Okay, well then, I guess in the best interest of peace, in regards to your violence, I will go ahead and relax for a minute, but let's get with it. I got things to do. got it?
What was that just thrown?
Keys.
Do you know that person?
Yeah, they're my boys.
Okay. All right. So thank you. Mr. Haywood has been very disruptive. He tried to leave the courtroom once he was placed in custody. So just FYI, be careful with him.
So, give me a break. Can I just see just need to see it, thank you. Can I see who's being put into custody, please? I just need to see the name. I just need to see the name of the person. Okay, that's not me, that's the problem.
Our Sanborn's matter, we're here today on
That's not me. The name is saying it, but that's my registered trade name. I got all that documentation right here.
Okay, good.
You want it? Okay. Yeah. Well, this is the defendant technically.
If you want that, I can go with you, put everything, try that.
1 second. Well, that's taken care of.
We can think that can't even get the right name.
Did she file a notice of appearance?
I will make sure that she does, Your Honor.
Okay. Yeah, sorry, I haven't had enough coffee yet today. So yeah, no, you've got Ms. Bradshaw, so that's fine. You don't need to do those forms. But she does need to.
The final note of this courtroom story isn't music, but a reminder that authority can't be wished away. The defendant may have tried to dodge accountability with paperwork and declarations, but the system responded with clarity and consistency. The analysis shows how he turned the process into a performance, yet the judge and sheriff never strayed from the path of law. And the breakdown proves once again that sovereign arguments sound dramatic but collapse under the weight of enforcement. The entertainment comes from the sharp turn, watching bold confidence dissolve into sudden silence once reality enters the room. And each case like this exposes how fragile these fantasies are while showing why courts must stay grounded in rules, not rhetoric. In the end, the law prevails, the paper defense fails, and the audience walks away with both justice and amusement. Thanks for watching. Don't forget to like, share, and subscribe. And stay tuned because the next wild courtroom meltdown is right around the corner.